res ipsa loquitur, abracadabra, caveat emptor, avada kedavra. Why do lawyers use such funny words? It actually has nothing to do with lawyers inventing highfalutin legal words in order to sound smart. We're that already. And as a graduate of both law school and Hogwarts, I can tell you that lawyers don't have magic words. But over time, all professions build up a special vocabulary to help describe things in very specific language. And usually, it's not magic. But sometimes it is sort of magic. And when Mark Jaffe posted on Twitter, what genuine law term sounds fake? You have to convince people you didn't make it up. I knew I had to share some of the most ridiculous legal terms out there. And if I have to deal with these legal terms every day, I'm taking you legal eagles with me. Sponsored by CuriosityStream and Nebula. All right, so the first ridiculous legal term that we have to deal with is Pendente Lite. Now, you might think this is a Mexican locale beer. Pendente Lite. Taste the lawyer. Or maybe it's a fancy pendant light. Or perhaps it is the lowest weight class in boxing, Pendente Lite, one step below the 108-pound flyweight. But what it actually is has nothing to do with YouTubers turning into boxers. Pendente Lite is a Latin term meaning awaiting the litigation or pending the litigation. You often see this during divorce and custody litigation. A court can issue a temporary order of support, Pendente Lite, to maintain the financial status quo of all parties of the divorce while it's pending. And court orders are often used to provide relief until the final judgment is rendered. And the adverbial form of this, it would be a lis pendens, but that's also its own special legal document, usually regarding real estate. Ugh, God, this is already getting incredibly complicated. But on to the second ridiculous term, which is Champerty. Now, you might think that Champerty is a character from the TV show Bridgerton.
Announcing Lady Champerty of the North Hampsteadshire upon Tim's Champerties.
Might be a fraternity drinking game. It might be something people on HGTV's House Hunters would complain about not having in their home, like the Champerty water fountain for their dogs. But what it actually is when a third party funds litigation. Now, historically, this was known as maintenance and Champerty. Back in the Middle Ages, nobles started funding frivolous lawsuits to buttress the claims and take a share of any profits for themselves. And Black's Law Dictionary defines this as a Champertus agreement, as a, quote, bargain between a stranger and a party to a lawsuit by which the stranger pursues the party's claims in consideration for receiving part of any judgment of the proceeds. And perhaps the most interesting thing is that these days, these kind of agreements are generally not illegal. There's a whole world of litigation finance out there that in the olden days would have been considered Champerty and illegal. For example, now a hedge fund could invest in litigation that the plaintiffs couldn't afford to fund on their own. It actually allows more people to access the justice system than otherwise would be able to do because of the funds that they or their lawyers do or don't possess. But on the other hand, the funding party could be a billionaire who has a grudge against someone else, as we saw with the Peter Thiel lawsuits through Hulk Hogan against Gawker. So it's, a double-edged sword. But that takes us to the next ridiculous legal term, which is Mutatus mutandis, which could be the High Valerian for all lawyers must die. It could be an outtake from The Lion King giving Timon and Pumbaa a follow-up to Hakuna Matata.
What a wonderful phrase.
Or it could be the title given to the most important praying mantis in the world. Well, actually, it's a Latin phrase that means with things changed that should be changed, or having changed what needs to be changed. It pops up a lot in legal circles when lawyers are drafting contracts. The simplest explanation is for use in the law in that the necessary changes in details such as names and places will be made, but everything else will remain the same. That explanation comes from the famous Judge Scheinlin, no, not that Judge Scheinlin, Judge Shira Scheinlin, who is well known to all lawyers for her groundbreaking decisions in electronic discovery, which still form the backbone of federal rules that govern electronic information in litigation. Which takes us to the next ridiculous legal term, the suggestion of death. Now, is the suggestion of death a proper way of insulting opposing counsel? I move to strike opposing counsel upon suggestion of death. Is it a spell or event from Dungeons and Dragons? Is it what happens in the Oregon Trail when you unsuccessfully try to ford a river? Or is it a Charles Bronson movie, Suggestion of Death, from the producers of Death Wish and Chasing Amy? Well, actually, according to Henry Campbell Black, the man who literally wrote the book on legal terms, he explains that a suggestion of death is a, quote, statement formally entered on the record of some fact or circumstance which will materially affect further proceedings in the cause. I know it looks weird since a person's death is usually not a suggestion, it's a fact, but a suggestion of death functions as a legal announcement of death, and FYI to inform the court and opposing parties that a key person has died. A case doesn't necessarily go away just because someone dies, although that can happen. But this is just a lawyer's way of letting everyone know that something kinda major has happened in the case. Which takes us to the next ridiculous legal term, an attractive nuisance. Is an attractive nuisance the person you run into a bar at last call?
You feeling what I'm feeling?
If it's resignation, then yes.
Is it the song that you can't get out of your head? Is it free cake in the office break room when you're on a diet? Is it when your pets or children are annoying you while you're trying to work from home, especially when you're on a Zoom call?
Pardon me.
Well, actually, an attractive nuisance is something that's on your property that is attractive and exciting to children. Property owners have a special duty of care to children and teens because they can't fully understand the dangers posed by certain situations. This means that if you have a bucket of candy or a PS5 sitting on a float in your swimming pool, you might expect the children are going to trespass onto your property. And while often you're not obligated to protect trespassers, sometimes you have to look out for those stupid, attractive nuisance children. In other words, you're obligated to mitigate the danger by taking steps to prevent them from accessing the property. Put up a fence, cover the pool, and keep your video games downstairs in your mom's basement. Which takes us to the next ridiculous legal term, a heart balm tort. Now, a heart balm tort could be an assignment on the Great British Baking Show, probably something really dumb like a whole peach wrapped in 1,000 layers of pastry and then baked for some ridiculous amount of time, like 12 hours, could be, bloink.
Love the flavour. It's a charming cake. Little bit of a mess.
Thank you so much.
It could be a magic spell. I command a level 5 heart balm tort against you. Or it could be a Hallmark movie about a down and out heart surgeon, Michael Balm, who leaves his big city practice to start up a bakery and falls in love with a woman who can't stop eating his mini pies. But actually, a heart balm tort is a specific kind of civil suit, often referred to as a tort, that is brought against someone who has interfered in a relationship or made a promise that they didn't keep. This lets people sue their spouse's paramour or bring charges against men who promised to marry someone but then backed out. These suits flourished in the early 20th century when newspapers featured lurid tales of gold-digging harlots who broke up marriages and then preyed on widowers. Eventually, there were so many heart balm tort cases that they were actually abolished in more than 40 states. But that takes us to the next ridiculous legal term, a frolic and detour. Now, is a frolic and detour a pair of animated mischievous kittens, as in Tom and Jerry, Itchy and Scratchy? Is it the new Michael Chabon novel? Or is it the newest Kardashian baby name, Frolic and Detour, along with Rumor, Scout, Apple, Northwest, and Elon Musk's formula? Well, actually, it's a term that covers the little side trip that an employee takes when they're supposed to be on duty. And of course, when accidents happen. Who's responsible when an employee does something that's on their own, but on company time? Well, generally, employers are liable for any damages caused by their employees. But if someone is acting way outside the scope of their job, the employer might be able to show that the employee should be held legally responsible. A frolic is when an employee totally departs from his or her duties. Let's say your boss sends you to Office Max for supplies, but on the way there, you stop off at a casino to play some slot machines for an hour. And on the way back, you get into a traffic accident. The trip to the casino is completely unrelated to your job duties, so the employer won't be legally responsible. On the other hand, a mere detour is just more of a minor deviation that probably doesn't absolve your employer of liability. For example, if you go to Office Max in our example, and then stop at Starbucks on your way back, and then get into a traffic accident, in this instance, you've probably only made a slight deviation from your job duties, so the accident may be within the scope of your job and your employer might have to pay for the damages. But that takes us to the next ridiculous legal term, quiet enjoyment. Now, is quiet enjoyment the nap time at a Montessori school after you have already played a game of Heads Up 7-Up? Is it something your parents desperately want, especially during COVID? Or is it a cover band for Quiet Riot? Well, actually, quiet enjoyment comes up in the real estate context. It's usually a covenant of quiet enjoyment and is one of the promises that a property owner or tenant gets as part of his or her right to possess and use the property. This means that the person has the right to enjoy the property without interference. This covers things like a landlord repeatedly harassing a tenant or vermin inside the walls making noises at all hours of the day and night. If you are renting property, you have the right to quiet enjoyment, and that might mean you're able to listen to Quiet Riot. But that takes us to the next ridiculous legal term. This one is one of my favorites, a fertile octogenarian. Now, is a fertile octogenarian Mick Jagger, Larry King, a rejected Pokemon, or the title of TLC's newest hit reality show, I'm Marrying a Fertile Octogenarian? Well, a fertile octogenarian may actually refer to all of those things, but in a legal context, it means something very specific. This usually involves property law and is the source of many headaches for law students. Because a fertile octogenarian is a fictitious character that we make up in property law to demonstrate the concept against the rule against perpetuities. And while it often takes a long time to wrap your head around it, it's actually kind of a simple concept that is meant to make sure that there is certainty about who gets what. If you're going to give property to a certain category of people, you have to know that all of those people are certain within 21 years of the death of the person who is living. So for example, if you said, I give all of my property to Aunt Bertha, who is 100 years old, and all of Aunt Bertha's children. Well, the thing is, even though Aunt Bertha is 100 years old, the law presumes that she could have more children. So that bequest doesn't work because it violates the rule against perpetuities, because we assume that even if you're an octogenarian, the law thinks that you still could be fertile. Look, I don't know, the law is weird. What do you want from me? But that takes us to the next ridiculous legal term, an unborn widow. Now, is an unborn widow an Amish romance novel? Is it a sad Bon Iver song, which, is there any other kind? Or is it a Christian horror movie about a ghost that was never born because the couple used contraceptives instead? Well, actually, an unborn widow is actually related to the last fertile octogenarian. Yes, property law is the gift that keeps on giving. Now, let's say you had a complicated will and you wanted to leave a house to, let's say, Gary for his life, and then to Gary's widow for her life, and then to Gary's children after they pass away. Now, the property can't be given to Gary's widow until Gary is dead, which is totally fine from a legal perspective. But property law asks us to assume the most ridiculous far out thing imaginable. Like, what happens if Gary marries a woman who isn't even born at the time that you made the gift to Gary? What if Gary is actually Mick Jagger and you left him a house back in 1980, but Mick Jagger later marries a woman born in 1999? But here's the problem. He could die and then his new bride could outlive him for way longer than 21 years. And the rule against perpetuity says that the interest must vest within 21 years. So that transfer would be invalid from the outset because of the possibility of the unborn widow. But frankly, I think my movie idea is a way better one anyway. But that takes us to the next ridiculous legal term, a precocious toddler. Now, is a precocious toddler a hit podcast for moms who know that their toddlers are gifted? Is it the name of Gwyneth Paltrow's baby store? Is it a never-made Adam Sandler movie starring Kevin James as Adam Sandler's son? I mean, who wouldn't want to see that? I'm just full of great movie ideas. But in reality, a precocious toddler goes back to property law once more and our favorite rule against perpetuities. Because we've already talked about how the law requires you to believe completely insane things like an octogenarian, being fertile, or the ability for anyone to marry someone who isn't even born yet. And if you have to assume those things, you better believe the law requires you to think that everyone is fertile at birth. I went to law school for this. Frankly, this is all just jiggery pokery, which is our next ridiculous legal word. Now, is jiggery pokery a phrase that will get you fired from work because it's racist? Is it an old-timey card game that is racist? Is it a very outdated Disney park ride that seems just a little bit racist? Or is it a beloved vintage children's book that might be racist? Well, actually, children, this racist sounding phrase isn't racist at all. It's just some bizarre slang from England that Justice Antonin Scalia picked up. But it's a bit of a punt because it literally means legal nonsense. The earliest known use of this phrase was actually in 1845 by the Berkshire Chronicle in Reading, England. The article was called Protection to Agriculture, and it commented that under the present law, the averages were made up so faithfully and fairly as to prevent any jiggery pokery. And Justice Scalia deployed the phrase jiggery pokery to attack Chief Justice Roberts for the court's 6-3 decision that it was legal for the IRS to extend tax credits for the Affordable Care Act to federal exchanges as well as those created by the states. So that takes us to our next terms: flummery, tommyrot, balderdash, and poppycock. Now, no, those aren't technically legal words, but they do describe people who don't check out the extended version of this video over on Nebula. Is dicta the head coach of De Bears? Or is it the source of one's manhood? In fact, almost all of my videos have an ad-free extended version on Nebula, and now you can get a huge discount. Because sometimes talking about jiggery pokery is too hot for YouTube, which is why my creator friends and I teamed up to build our own platform where creators don't need to worry about demonetization or the dreaded algorithm. It's called Nebula, and we're thrilled to be partnering with CuriosityStream. Because Nebula is a place where creators can do what they do best: Create, and it's a place where we can both house our content ad-free and also experiment with original content and new series that probably wouldn't work on YouTube. So not only are my Nebula versions ad-free and extended, but they're also released early before the YouTube version. And Nebula features lots of YouTube's top educational-ish creators like Lindsay Ellis, H Bomber Guy, and Medlife Crisis. And we get to collaborate in ways that probably wouldn't work on YouTube and put out amazing original content like Half as Interesting's Courtroom Drama, where I play a real-life fake lawyer. Now, what does this have to do with CuriosityStream? Well, as the go-to source for the best documentaries on the platform, like Peter Sagal's History, they love educational creators. And we worked out a deal where if you sign up for CuriosityStream with the link in the description, you'll also get a Nebula subscription for free. And to be clear, that Nebula subscription is not a trial. It's free for as long as you're a CuriosityStream member. And right now, CuriosityStream is offering 26% off of their annual plans. That's less than $15 a year for both CuriosityStream and Nebula together. So if you click on the link in the description, you'll get both CuriosityStream and Nebula for 26% off, or you can go to curiositystream.com/Legaleagle. It's a great way to support this channel and educational content directly for under $15 per year. So just click on the link in the description. Plus, clicking on that link really helps out this channel. So do you agree with my analysis about all these crazy legal terms? Leave your objections in the comments and check out this playlist over here with all of my other videos about crazy laws and legal misunderstandings. So click on this playlist or I'll see you in court.